Hello, this is Matt on the Moon Lambeau channel. We have a brand spanking new legal brief from Ripple, which attorney Jeremy Hogan has stated quite appropriately is the hardest hitting in the case yet. And you'll see exactly why. So you can hear that? Got some dead trees up in my little Moon Lambeau hands right here. And I highlighted the parts that are most interesting. And so much of it is interesting. I tried to keep it down. Like, there are all sorts of parts where I was like, I love the way that they worded it, but it's somewhat similar to something else, so I tried to trim it down, because otherwise the video would just go on for like 50 minutes. So I'm trying to just get to the meat of it. But some of these comments are just so good. I've got to share some of the stuff. You guys are just going to be... If you're like me, I mean, it's powerful, and so it feels good to see like the case really being taken to the SEC because of all the nonsense they've been stating. But also some of it just kind of made me laugh, because the way that Ripple's attorneys worded it, again, absolutely appropriate, but it highlights the degree to which the SEC has just been completely absurd. And so what we're talking about here is basically, it's getting to the core of the most recent developments in which the SEC is flip-flopping on its position, initially arguing that former Director of Corporation Finance Billy Boy Hinman's speech in 2018, the Theory of Free Pass speech, they stated that it was just his personal opinion. They were arguing that until it became beneficial to argue that it's actually the official position of the Division of Corporation Finance, not just a personal opinion. And the reason that they're flip-flopping on that is that it's an attempt to claim privilege, because if they can claim privilege over documents associated with this speech, then they don't get into the hands of Ripple. And the fact that they're fighting so tremendously hard, I think it speaks to the degree to which they're just desperate to not get the truth out, because it's highly likely that these documents, as Ripple's attorneys point out, would probably substantially benefit Ripple's defense. So anyway, plenty to break down, but before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice. You definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out to Attorney James Filan, member of the XRP community, for sharing this most recent legal filing. And you can see he summed it up by writing the following. Ripple and the individual defendants have filed their opposition to the SEC's motion for partial reconsideration and clarification of Judge Netburn's DPP rulings, that's privilege, DPP, deliberative process privilege, noting that the SEC is simply seeking a do-over. And then in a separate tweet, Mr. Filan wrote one word, BAM, B-A-M, in all caps. And there's a reason that there's a lot of excitement from the attorneys that in our community that have been covering this stuff. It's a very strongly worded document. And so Jeremy Hogan saw that and wrote, when Jim says BAM, you know it was big. And I've got comments from attorney Jeremy Hogan and also John Deaton on this. Oh, by the way, I meant to mention this right at the intro too. We're going to talk a little bit about the concept of dismissal. Have things gotten so bad for the SEC in this case that the SEC will actually just throw the whole thing out? Well, attorney Jeremy Hogan and John Deaton share their thoughts on that, and that's going to be at the very tail end of the video, but let's get through this. So I'm going to jump in. Again, I just highlighted some of the parts that I found to be most relevant. Here's the actual legal brief here, written by Ripple's legal team to Judge Netburn. The SEC's motion is an inappropriate attempt at a do-over simply because it is unhappy with the court's order on its prior briefing. The SEC makes no pretense that the demanding standard for reconsideration is satisfied here. Instead, it seeks to yet again brief an issue that has been extensively litigated for nearly a year, but this time based on a new theory. It's so true. They completely changed their story, folks. And a reversal, of course, ignoring its prior briefing and a sworn declaration it procured from former Director of Corporation Finance William Hinman, in which the SEC maintained that Mr. Hinman's speech simply expressed his personal views of the speaker, a position the SEC now knows cannot support its privilege claim. The SEC now argues, for the first time, that the speech was the culmination of and reflected a policy process within the Division of Corporation Finance. And so this reversal contradicts Mr. Hinman's sworn statement. Now, that's all very obvious stuff. To anybody with half a brain, which is why I don't see how this particular matter doesn't go in Ripple's favor. That would be astonishing. That would absolutely be astonishing. Take a look at this part now. And for all its tactics, the SEC ultimately fails to establish that this court's January 13th, 2022 order was in error. The SEC cannot show that the court overlooked any factual matters before it. The court considered and credited both Mr. Hinman's sworn statements and the SEC's representations that the speech expressed Mr. Hinman's personal views. Moreover, the court already recognized that the SEC staff were involved in discussions around the speech and determined that those discussions were merely peripheral to actual policymaking. So if the court's already making this has made this clear, and that's why Ripple's attorneys accurately stating they're basically just seeking a do-over. That's what the SEC is doing. They just want to give another crack at it. That's not how this works, though. I mean, they'd have to show a factual error. And so part of what they cited there is just a matter of actual policy and procedure. If you were going to get anything remotely resembling a do-over, you'd have to show that there was sort of notable grievance, effectively, so, genuine core facts that were supposed to be considered and analyzed that actually weren't. There's nothing even approaching that, not even close, as Ripple's legal team points out. Now let me scroll a little further here. Ah, yes, here we go. I like this line. Here's a good one. As a matter of basic fairness, having taken and maintained the position that Mr. Hinman's speech reflected only his personal views, the SEC cannot be permitted to backtrack to avoid the natural consequences of its own litigation strategy. Oh, I love that. That is powerful. Because Ripple's acknowledging what we all see here. The SEC's policy, or a procedure, how they've been going about this litigation, their entire strategy, the entire game plan, it's not working out, and that's why the SEC is revamping that, midstream here. And that this is Ripple calling them out exactly for that. Again, the words, you can't be permitted to backtrack, change your policy, just to avoid the, quote, natural consequences of its own litigation strategy, end quote. Gotta love this stuff here. I'll tell you what, man, this hot gem slaps. Then there was this line. The SEC seems to argue the speech should fall within an administrative twilight zone, somewhere between a personal view and agency policy. I was laughing when I read that one. The SEC seems to argue the speech should fall within an administrative twilight zone, somewhere between a personal view and agency policy. That's basically what they're arguing, right? As if there's three new categories, or three total categories, in which to consider who or what an opinion came from. There can be a personal opinion, there can be a division opinion, and an SEC position, and they're arguing that all three of these things are different. And you can argue successfully that the personal opinion is different, but you're not going to be able to argue successfully that the division opinion is different than the SEC's opinion itself. What the hell is the SEC? At some point, you've got to ask that. And so if you look structurally at the SEC, there are several primary departments right at the top of equal value. And what is it? Is it written somewhere? It's not. But is it written somewhere that all four of these divisions, or several divisions at the top, they must all decree that at the same time, just in perfect harmony, this is the official position of the SEC, or else it's not? It's a completely silly, just completely absurd position to take. I've never heard of that being argued before. Go SEC, I guess. Then there was this. A little bit later. Here, I'll just scroll down. It was on page 8, I think, here, right? What the hell page am I on the screen? Here we go. Yes, all right. Towards, here, I'll just highlight part of this. It's right around here. They wrote, defendants have been seeking discovery on this issue for more than a year, and the SEC may not, at the 13th hour, suddenly start over on a fresh theory of privilege. And it is kind of absurd, you gotta admit, we're this far along, and things just aren't going well for them, so we're just gonna start from scratch. You know the judge isn't gonna see through this, right? There's like almost a 0% chance, right? I have no legal background, and I can't fathom, I know, I'm just saying, I think you don't need a legal background just to see how bad this is for the SEC, and how illogical it is. Then they also wrote, in a case where the SEC alleges that it was at least reckless for Mr. Garlinghouse and Mr. Larson to fail to recognize Ripple's sales of XRP as an unlawful securities offering, oh, I love this, powerful. It is highly probative and potentially exculpatory that those within the SEC itself, the plaintiff in this case, struggled with the very same question. So much so it took them 52 drafts to get it right in Mr. Hinman's speech. Think about that, folks. And again, this goes back to this whole idea I was saying earlier in the video. It's like, why do you think the SEC is fighting so hard? And they have to know that their arguments are piss poor at this point, but they're arguing so hard because they know, I suspect, that this ruins their case. This could outright ruin their case because, again, what's one of the big questions? You know, is there market confusion or is there not? Is it so clear that what Ripple did was wrong in selling XRP and the way they went to market? Is it so clear that what they were doing was wrong? Or is the reason that the SEC is fighting so hard to hide these documents that are linked to the Bill Hinman Ethereum for Pass page? Are they fighting that way to hide those documents because included in those documents, it shows the SEC struggling with the very same questions surrounding XRP and the broader crypto space? Might that be it? I think that's perfectly reasonable speculation. In fact, highly probable at this point, especially seeing how desperate the SEC seems. And then there was this at page 9. The SEC's decision to charge Mr. Garlinghouse and Mr. Larson individually in this case was exceptional and distinguishes this case from virtually every other digital asset case the SEC has brought. So does the fact that XRP was circulating globally in the billions of transactions for nearly 8 years before the SEC filed this case against Ripple. The defendants have a strong interest in accessing the evidence at issue, as it is likely to be exculpatory insofar as it shows uncertainty within the SEC itself and the SEC's awareness of market confusion, thereby undercutting the SEC's allegations that the status of digital assets like XRP under the securities laws was obvious. Exactly. So if it's not obvious, then Ripple really does have something to go on here regarding fair notice. They're fair notice defense. What I'm saying, like, if they're allowed to argue this, that's got teeth. That's what the attorneys within our XRP community have been saying, and it seems to be very true. It's just astonishing here. It really is just truly astonishing here. Because that must be what is in these documents. That there must be acknowledgments that there's market confusion. I don't, what the hell else? Otherwise, it makes no logical sense for the SEC to be fighting so hard with these documents specifically. It really doesn't make sense. And so Attorney Jeremy Hogan, he wrote the following about this legal brief. Wow, I expected Ripple to come out swinging, and this brief did not disappoint. This is the hardest hitting brief thus far in the litigation, and rightfully so. The SEC has spun itself a tangled web here, and I don't expect the judge to help them out of it. Yeah, sounds about right. Here's a response to that from an attorney named Bill within the XRP community, and he wrote the following. Fully agree. Very hard-hitting brief. There are no certainties in litigation, but I struggle to see how, on the merits, Ripple does not win the motion for reconsideration. And my recollection is that the judge did not allow a further reply by the SEC to Ripple's response. And then there was this, Attorney John Deaton, and he was sharing parts that he found interesting. Part of what Ripple's attorneys here wrote, the SEC now seems to suggest that Mr. Hinman's sworn declaration and deposition testimony were at least misleading. And then John writes, at first, the speech was his personal opinion, which triggers a Title V violation. The SEC's new theory, if true, makes Billy Boy a liar. And so what he's talking about there is that it's Title V, he's referencing just the fact that you can't benefit specifically from things that are occurring under your watch, your role as an executive at the SEC. And so, if this really was just his personal opinion and he profited to the tune of millions of dollars, and he did profit of that, John Deaton here is saying that's a Title V violation and you could be in serious legal trouble. But if the new theory is true, then Bill Hinman's just a liar and it's not just his personal opinion. It's the official position of the Division of Corporation Finance, which is completely absurd, of course. And then there was this. An individual from the community named Jimmy wrote the following. Question for the Brain Trust. Dismissal with prejudice? Question mark. Possible, likely, unlikely, why? And so what he's getting at here is, he stated in a tweet that was also retweeted, and he said, regarding the case, could it be dismissed with prejudice? That's basically what we're getting at here. Would the SEC actually just dismiss the case? And Attorney Jeremy Hogan wrote back with the following. In my opinion, a dismissal is almost the same as a loss for the SEC. It would signal to the market that they can't prove their case. So I don't see it happening. Instead, the SEC would approach Ripple to enter a settlement, which it can claim as a victory. And then Attorney John Deaton saw that, and he added the following. BlockFi agreed to pay $100 million, and the SEC got to claim it held BlockFi accountable. I can't speak for Ripple, but if the SEC agreed to a settlement that declared today and future sales of XRP not involving securities, I imagine Brad Garlinghouse would immediately write a similar check. Yeah, so John Deaton seems to agree with this concept here. Settlement, perfectly plausible. Dismissal, not quite so much. And then somebody named Silver Surfer responded to John there and wrote, would Ripple allow it to be spun as a victory for the SEC? And John wrote, any settlement will come with an agreement not to disparage the other side. If Ripple could get certainty regarding XRP and move forward with an IPO and the business plan, I'm sure they wouldn't care how the SEC spins it. Garlinghouse is too savvy and smooth to hold a grudge. And so there you have it, folks. That's the latest in the nonsense. That is the SEC versus Ripple case. Please let me know how ridiculous you think this all is in the comment section below. I love hearing from y'all. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.